number 23, the people of the state of New York versus Kathon Anderson. Counsel?
Good afternoon, Your Honors. Cynthia Colt of Appellate Advocates for Appellant Kathon Anderson. Your Honors, in this case, the trial court committed
Ms. Colt,
reversible...
would you like to reserve, excuse me for
Oh,
interrupting?
yes,
some
thank you for
rebuttal
reminding me.
time?
Yes, 2 minutes, please.
Sure.
Thank you. Your Honors, the trial court in this case committed reversible error when it barred defense counsel from calling the leading expert in adolescent brain development and behavior, Dr. Lawrence Steinberg. Dr. Steinberg would have testified that the adolescent brain differs fundamentally both in structure and function from the adult brain.
Counsel, if we were to find that this testimony should be permitted, where do you draw the line? I mean, here you have a 14-year-old who is apparently below the lower range of what this particular expert indicates is the is the range at which the adolescent brain is developing or whatever. So at what age? I mean, is it at age 20, at 15, 16, 17, 18? Is there a particular age at which it's no longer relevant, or how do you draw that line?
Well, I think, as you said, first, Kathon Anderson is at the very bottom level where all these differences are much more pronounced. He was 14. But I think that the Supreme Court has drawn the age for this topic, for this scientific evidence at 18, or at least they've relied on this evidence to draw the line at 18.
So anytime you're dealing with an adolescent under the age of 18, then this testimony becomes relevant?
No, not at all. I think relevance is a whole separate issue. It was particularly relevant in this case because the jurors had to assess the reasonableness of appellant's fear that he faced imminent deadly physical harm by these rival gang members. So there was this subjective element they had to determine, and this court has been clear. People v. Wesley, trial counsel cited, People v. Getz, that the jurors must stand in the defendant's proverbial shoes to assess the reasonableness of his perception, of his fear, and they must do it based on his circumstances and his background and his characteristics. In this case, really a significant characteristic of Kathon Anderson was the fact that he was 14 years old. He had an undeveloped prefrontal cortex, which regulates decision-making. It's the executive functioning part of the brain. And then he was, as a 14-year-old, he was significantly influenced by that, by relying on the amygdala.
Well, I think you have an interesting dichotomy here because all these things sort of play together in my view. But here you have the people wanting to assert that there's a combat by agreement, okay? And the defense doesn't want that because that goes against the justification defense. But in some ways, all these Facebook posts and all this other stuff and the proof that goes toward the combat by agreement would also support the argument that he had a reasonable fear of deadly physical force, even though there were, no weapons that were, shown or anything like that. So how do you
I
reconcile that?
Reconcile the fact, I do agree with Your Honor that some of the gang evidence, the fact that Mr. Anderson was in a gang and that he was confronted by a whole group, plus the 3 on the bus, of rival gang members, and the fact that the rival gang members, a police officer testified they were known to shoot at their rivals and publicly post about it, that did go to his reasonable belief that he was in deadly physical force was imminent by these gang members. But I think all the evidence, his Facebook evidence, really worked against him in a lot of ways because on one hand we have a 14-year-old child and defense wasn't able to present evidence of what this entailed as a group characteristic.
Was there a problem with the expert proffer in this sense that because he was a gang member that the expert would not be able to address sort of how that might affect this particular defendant's perspective in the moment?
Well, no, I don't think so, because I think it was a group, first it was a group characteristic of 14 years old. All 14-year-olds have an undeveloped prefrontal cortex, all 14-year-olds, as a group characteristic, rely
Not all
on
Wasn't that, though-
14-year-olds join gangs and kill people, so the question is whether or not the expert, because the expert was limited to just that testimony without what it may be particular to this individual, could really speak to the issue.
Well, it could speak to his emotional and his fear, which was the issue the jurors were charged with assessing. But this particular, I mean, this isn't in the record, but having read about this particular expert, I think he probably would have had a lot of testimony about a teenager's involvement in a gang and how that's actually very consistent with the teenage brain, the peer affiliation.
Can we just take a step back as to a teenager's ability to exercise executive function? The way I understood the trial court's ruling, they seem to be saying, in the appellate division also, that the emotional immaturity and intellectual immaturity of a teenager is within the ordinary ken of the average juror. How do you respond to that?
Well, first, she said that the impulsiveness is within the ordinary ken. And that really wasn't
That's
the
right, yeah.
extent of the expert testimony in this case. Maybe that's one aspect of this lack of brain development, but other aspects that were particularly important, and trial counsel pointed this out to appellant, was that in particularly stressful circumstances, negative emotional stimuli, those are the precise circumstances where the teenage brain really comes into play.
One of the other aspects of kind of the convoluted way that this case has come up to us is that while combat by agreement was rejected by the appellate division as an exception to a justification defense, the initial aggressor charge wasn't. And what do you say about the proof in the record on the initial aggressor charge?
Well, again, that does include that he has a reasonable belief that deadly physical force is about to be used against him.
What was the objective indicia of deadly physical force being threatened against him that's in this record?
That's in this record is that the bus he was on was stopped by rival gang members. And trial counsel, when you count, I think he counted 8 rival gang members. They were at the front of the bus holding the door, and the bus driver testified she wanted to get them out of there and close the doors. They would not let her do that. There was gang members at the back entrance, also guarding the back entrance. They were all communicating with each other. And the people put in evidence that this rival gang was known to shoot their rivals, and
Well,
even...
we could see the video. I mean, I watched the video, it was in
Yes.
the record, and it looked like they were about a third of the way down the aisle to halfway down the aisle when the defendant shot the gun off. But there was no showing of weapons, just rushing towards him to attack him.
That's true, Your Honor. On the video, there was no show of weapons, but I don't think that is
Can you
conclusive.
identify a case, sorry, over here, where there's not a show of weapons and there's not a specific threat from person A to the defendant, where the defendant brandishes a weapon, uses a weapon, and is not deemed the initial aggressor?
My case law, no, I did not find that specific case, but this case has a lot of other elements and a lot of evidence that...
But would you be, to follow up on Judge Wilson's question, would your expert testimony then be being used to bridge that gap in our case law?
No, I
That
think...
instead of showing a weapon here, you can have expert testimony on frontal lobe development?
No, and I don't think that was the purpose of the testimony, Your Honor. The video wasn't conclusive evidence that they weren't carrying guns, and I don't think it was conclusive evidence of the fact that Mr. Anderson did not reasonably fear
But
that they
there's
were...
no testimony that he ever saw a weapon, right?
No, there is not.
And there's no testimony, I think the testimony was they didn't recover any weapons from from anyone, right?
Of some of the ones who were stopped, that the police officers
Right.
stopped. But, I mean, as you know, that people are able to, we hear all the time in cases
Well, you know,
of people.
when you look at it, you'd say, all right, they're initially aggressing at him in the sense that they're coming at him, but he brings out deadly physical force. So is it a reasonable belief for him to bring out deadly physical force? I don't know the answer to that question, but also, if it was an overreaction, is his overreaction, your argument then is his overreaction as a result of his limited prefrontal lobe development? In other words, it's more than just an average teenager.
Yes, his perception of the fear and that they were armed and his reaction to it was, the expert's testimony certainly would have explained that and explained his thought process and how his thought process.
Doesn't that go to what I was asking you before? Then that fills the gap that there's no indication that there was any weapon here. So you're saying because of his development as a 14-year-old, he would have perceived deadly force was going to be used against him, where otherwise, let's assume under our case law, we have never said that under these circumstances.
I guess in one sense, then it would bridge the gap to some extent, but
Well,
there's,
it goes directly to what Judge Stein was saying also, is that the combat by agreement proof might support where he got that belief from, but this case has come to us in a convoluted fashion, so in some ways, it demands some legal and logical parsing.
Counsel, let's say there's not a combat by agreement in the sense of each gang says, we're going to get you, and they have this understanding that that's the way they're functioning. But if a gang member is aware that if you enter the rival gang's turf, the consequences are perhaps death, is that also what, I'm just trying to be clear, this is in part trying to understand your response to Judge Garcia. Is that part of what you're arguing that exists, putting aside what the expert might have said about whether or not a 14-year-old under the circumstances would have believed that?
yeah,
is that-
definitely. And I'd like, the combat by agreement, I'd sort of like to put to the side because that, in the end, really worked against.
So does
Mr.
that mean
Anderson.
anybody who goes into a neighborhood that perhaps does have a high crime rate, maybe is known for weapon-based robberies, might, someone comes up to them and they think they're going to be robbed, they think they're going to pull a gun, so they pull a gun and they're justified in doing so? Is that what you're trying to say?
Well, no, because I think we have more than that here.
Okay.
We have the fact that he was riding, first of all, he's riding the bus, so he's in an enclosed area. The gang members and the DA in her summation even said there's no question they acted aggressively toward this young man. So there's no question that at the very least they were initial aggressors in acting
I
aggressively.
guess my problem is I too watched the tape, and I saw those boys get on the bus coming down, and I also saw the defendant jump up, pull out his gun, and shoot on the bus. So again, I'm going back to, I'm not getting the display of deadly physical force that would justify him jumping up on a bus and shooting a gun.
Well, it goes back to the fact that he knows that these are rival gang members. This is aside from the expert, he knows that these rival gang members carry guns and shoot at their opponents. They haven't let the bus go, they've stopped it, so you have all these external circumstances where,
But isn't your point something different? Isn't your point that obviously he didn't make the right decision, and obviously he miscalculated? I thought your point was that we need to put an expert on to show why he made such a stupid and wrong decision.
well, an expert to show, yes,
Yeah.
what his thought process would have been, how it was based on the fear base, but at the same time, there was evidence that, along with the expert, that it made it reasonable for him to believe that they were going to
Do we
use
really
deadly...
want a rule
Sorry.
that says it's reasonable that because you're in a gang and the rival gang members approach you not brandishing weapons in a public place, in this case an enclosed bus, you can shoot? That's justified. You can shoot because they're rival gang members, they sometimes may kill you. So I'm in a public place and rival gang members approach me, they're walking down the aisle. I can start shooting, because that is reasonably the threatened use of deadly physical force. Put aside the expert testimony. That's the
Well,
kind of rule from this?
Well, no, I don't think so. I think, as I said, there was lots of evidence in this case. Of course, weapons are not on the video. It's a shocking video in a lot of
Gang members
aspects.
is what you're arguing. The gang members,
Gang
they can be
members
more
who were
reasonable anticipating
aggressively
deadly
approaching-
force.
Gang members, sorry, Your Honor.
No,
Gang
but it
members-
seems like there would be a different rule for gang members then. Like, it might be reasonable if two gang members are walking down the subway car towards you because, hey, you're in a gang, they're in a gang, they may hurt you, they may kill you. So I can take out my gun and start shooting. Some people may be around, but I have a reasonable belief they may kill me, even though they haven't shown any weapons, but I know they're in a gang.
Well,
Why would we want that
Again, it
rule?
would depend on the circumstances. In this case, he couldn't escape because the bus was surrounded, so we have in many circumstances, there is the ability to retreat, to safely retreat. In this case, I don't think there's any question that there was no ability to safely retreat.
But let's say same facts, he knows they don't have guns. Could he still shoot? Because he still can't retreat. He still has to think there's deadly physical force going to be
Yes.
used against him.
And under the facts of this particular case, it was reasonable for him to believe that. And that belief was supported, would have been supported also by the expert testimony of what he was relying on. He was relying upon the fear-based part of his brain.
So
he-
let's say he's not a gang member. Let's say he's refused to join the gang. He's in fear of the gang nevertheless. And he gets on the bus, and he just knows that these gangs are violent, and he's turned them down. Maybe that's a wrinkle in the hypothetical. Can he pull out that gun? Does he have to have that? Would it be, again, an abuse to preclude that kind of testimony under those circumstances? Is he an initial aggressor under those kinds of circumstances?
An abuse to preclude...
As opposed, let's just take out for one moment that the individual is a gang member. Just trying to see where this rule is going, that
Right.
you're suggesting to us.
And then it would...
But it knows about gangs and is fearful.
Right. Are you talking about the rule concerning the expert witness at this
Both,
point?
both. And that on the initial aggressor.
Well, the expert witness still, if it's a 14-year-old, I think that his testimony should still be admissible and not excluded, a blanket exclusion of some...
Even if that expert may not be well-versed on issues related to gangs.
Yes, because this expert, even though, as I said, he does have a lot of writings about that, but he's mainly an expert on adolescent brain development and behavior, and much of what he would have testified about would have been that adolescents have, are much more stress responsive than
And on the
adults.
initial aggressor?
So
Well,
before you leave that point, isn't the thrust, let me get this straight in my head, that the 14-year-olds are justified, of the argument that 14-year-olds are justified in responding violently based on their brain development? Isn't that really an argument for saying that 14-year-olds across the board shouldn't be culpable of murder?
No, I don't think it is at all, because this was just testimony, evidence to go before the jury, so that they could decide from from, like I said, the proverbial...
Talking more at a policy level.
I don't think this does create a policy, like the trial judge said, because in...
Isn't the effect of that, even though it is a jury question, isn't the effect of that to make it easier for somebody who's 18-year-old or under to get an acquittal in a circumstance where somebody who's 19 couldn't? As an overall matter, isn't that the effect of what you're asking for? Just focusing on the expert testimony.
In similar circumstances?
Yeah, everything else is the same.
Because I'm not saying that an expert testimony in adolescent brain development and behavior should be admitted in any case of a child under 18, because in this case, it was particularly relevant because of the circumstances and the stress response. But I guess if you have similar circumstances of a 16, say he was 16.
No, my question is, if he'd been 19, you wouldn't be asking for the admission of this testimony, or 20 or 21, right?
That's true.
And so effectively, you're asking for a different rule that is going to make it easier for somebody who is under 18 to be acquitted in exactly the same circumstances than somebody who is 19 or 20.
Well, I respectfully disagree, Your Honor. I think I'm just asking this court to follow its expert testimony law, that where it's generally accepted science, where it's relevant to the issues that the jury is going to determine and to decide on. And if it's beyond the ken of the average juror, then it should be evidence that should come in at trial for a jury to consider.
Thank you,
mean-
counsel. Thank you. Counsel?
May it please the court, my name is Solomon Newbort, and I represent the people. The trial court did not abuse its discretion in precluding the expert testimony. The trial court correctly concluded that the conclusions that the defense counsel wished the jury to draw from the expert's testimony were not legally relevant and were not beyond the ken of the average juror.
I think this is a very difficult question, and I'm honestly struggling with it in terms of the expert testimony. But one of the things that's troubling me is, how is this different from testimony about PTSD or battered women's syndrome when it comes to the perception of danger and the response to it? They seem to be very similar principles, and and we've let in this testimony about PTSD and battered women's syndrome. So if we say that this is never acceptable testimony, then how are we endangering those other defenses?
Well, there are several answers to that question. First of all, the expert in this case was going to testify that adolescents do know the difference between right and wrong, this is a quote, but they just simply can't exercise the self-control. They don't have the regulative abilities that enable them to act in a right way instead of a wrong way.
Okay,
Now,
well, the court could have kept that part of it out, potentially, if that's troublesome. I'm talking about more about how the prefrontal cortex does and does not enable an adolescent to understand, to perceive fear and to respond in a way in which we would expect, rather than saying what you just said.
Sorry, Dr. Steinberg, in his own words, in his own writing, taken from his studies, say it's certainly reasonable to speculate that adolescents who commit crimes make more impulsive decisions than their adult counterparts because their prefrontal lobes are less fully developed, or because their ventral striatum is more responsive to rewards or emotional stimuli. However, this remains largely a matter of what I would characterize as sensible conjecture. More research that directly links age differences in brain structure and function to age differences in legally relevant capacities and capabilities is needed. So Dr. Steinberg never held that, or found, or the science states that the underdeveloped prefrontal cortex causes an adolescent to act one way or another. Now, that behaviorally, adolescents may be more impulsive than are adults, that's something that every adult knows. Every adult has been an adolescent at one point.
You see that as different from the expert testimony that is deemed admissible on PTSD and battered women's syndrome. You see those two as different? Is that what you're saying?
Well, one, the science doesn't back up in this case, according to Dr. Steinberg himself. And two, with battered women's syndrome, battered women is not necessarily something that the average juror knows how a battered woman will react. But every adult...
That's what they're arguing is that the average juror doesn't understand how an adolescent would perceive the circumstances.
But
not how they would act. I think when you're talking about impulsiveness, that's a different issue. And I think that they made that distinction.
But let's see what Dr. Steinberg has to say about perception of
Can I stop you
fear.
before you read to us for a second? I just wanted to follow up on Judge Stein's question. What I'm curious about here is is the fact that he wasn't allowed to testify, not the validity of his testimony, because no determination was made on that. Shouldn't there simply have been held a Fry hearing? And if your argument's correct, and the cross-examination would have brought that out, and that would have been the end of it. But isn't this issue significant enough to require that the court make a determination that as to general acceptance in the scientific community?
Well, in this case, Dr. Steinberg...
Let me just, you see why that's important for other types of trauma-induced violence, with domestic violence or PTSD, things like that.
Yes, Your Honor, but in this case, Dr. Steinberg hadn't examined this defendant. This defendant, as the people argued at trial, was not the typical adolescent. Where in response to that, defense counsel
Those
said,
are
well,
legitimate-
there's a range.
Let me slow you down. Those are legitimate points, but their argument, why not simply have the Fry hearing outside the presence of the jury and make a determination? Then we've got a record that we can look at and go forward from there. I'm wondering why that would be. What's the problem with that?
Well, Your Honor, certainly the trial court could have done that, but the question before this court is not what this court would have done, but whether the trial court abused its discretion under these circumstances in excluding the testimony by saying, I'm not going to have now a Fry hearing on something that's not legally relevant and in any event, this whole justification charge for which the expert was going to come in to help the jury determine was itself a gift, because the defendant wasn't entitled to the jury charge at all. The defendant...
Well, when you get to that, so then there are two aspects to that. One is whether there was combat by agreement, right? And then the other is the initial aggressor.
Correct.
Question, right? Well, it seems that both courts, the appellate division agreed that the combat by agreement should not have been charged to the jury. So if we take that out, then we're left with the initial aggressor exception, right? And wasn't that issue resolved in defendant's favor by the trial court? Didn't the court say that there was a question of fact about that?
Yes, but this court in People v. Butler said that where a court gives the defendant a gift, that doesn't inexorably tie that court to do everything that logically flows from that. So in People v. Butler, the decision to submit an intoxication instruction does not inexorably bind the trial court to instruct automatically on lesser included manslaughter offenses, even though logically it's the same. If the intoxication defense is given to the murder count, that would mean that the defendant couldn't form the intent to commit murder, which would mean that he could be found that he had acted recklessly, because intoxication is not a defense to recklessness. So it logically flows from the fact that the court gives an intoxication charge that should give the reckless manslaughter charge, but this court said that doesn't matter, and what really matters is the particularized evidentiary evaluation. So this court has to decide on its own whether or not the charge should have been given, and if the defendant wasn't entitled to the charge, it doesn't matter whether the trial court actually gave the charge. And I submit that in this case, the defendant was not entitled to the charge, because it's clear that the defendant was the initial aggressor, that the defendant used excessive force.
What if we disagree with you on that? What if we disagree with you on that?
Well, I still think that even if you disagreed with that, and even if you were to believe that the expert testimony should have been admitted, which I submit is not correct.
Well, certainly if it was, it would go directly to the initial aggressor issue, right?
No, I think that even with the expert testimony, even had it come in, even as we see it now, I don't think that a 14-year-old would have perceived that he was necessarily or at all that there was deadly physical force being threatened against him. He had been in skirmishes on this bus twice before without deadly force having been used. He lived in the neighborhood where there were rival gangs across the street. The testimony was that the rival gangs were just across the street from each other. He lived in that area, then he moved out, then he was visited. Not every time they saw each other was there necessarily skirmishes, and certainly not deadly skirmishes. And while there was this combat by agreement instruction, but the combat by agreement wasn't necessarily that every time they saw each other, they'd kill each other or use deadly physical force.
Can I ask you about the combat by agreement instruction? If we assume that that's error, I'm not saying it is, assume that it is, do you have a view on why it would be harmless?
I'm sorry, if we assume that the combat by agreement,
By agreement?
because there's no reason to believe that the jury ever reached that question, because in order to reach that question, they would first have to find that the defendant was justified in using force, and then come to the question of whether or not the justification would be taken away because there was this combat by agreement. But given the circumstances of this case, it's clear that the jury would have concluded from the fact that the defendant pulled out his gun before anyone even came towards him. He fired the shot when people weren't even a third of the way down the bus. He fired without warning. He then, after his rivals fled from the bus, he jumped over somebody in the aisle. He ran off the bus instead of staying in the relative safety of the bus.
Counselor, I thought that the people's alternative position was if we reverse that we should just reverse for a Fry hearing, get a determination on that. If the court rules against the defendant after a Fry hearing is conducted, then the verdict would stand, and if not, then he would get a new trial. I thought that was your alternative.
Well, my alternative argument is that if this court rejects that the instruction didn't have to be given, or the combat by agreement shouldn't have been given, and that it wasn't harmless, then a Fry hearing should be conducted. But if this court concludes that the exclusion of the expert was harmless, then there's no need to submit it for a Fry hearing.
Thank you.
Thank you, counsel.
Thank you.
Counsel?
Yes, Your Honors, I believe that all the arguments the DA just made about the combat by agreement charge are absolutely contrary to what the trial DA said. Her arguments were that a confrontation between the two gangs necessarily results in some type of shootout. And that was her whole argument for getting the combat by agreement charge. And, of course, for admitting all the Facebook posts. And I believe without the combat by agreement charge, there was a good possibility that Kathon Anderson would have been acquitted. This was a case that the first trial hung without even an expert. The second trial, the jurors asked to be re-instructed on justification, which included the combat by agreement charge. They deliberated for 2 days. So I think that the combat by agreement charge is actually a
Counsel,
very...
what about this argument that counsel made that the proffer on the expert about, adolescents do actually know right from wrong, they just don't have this impulse control, but nevertheless, the expert would have had to testify that they may not have impulse control, but the science isn't there that shows that lack of impulse control leads to criminal conduct.
Well, Dr.
That's the argument as I understand it, so what's your response?
I think he was talking the fact that Dr. Steinberg, because Dr. Steinberg is a behavioral scientist.
Yes, yes.
He's studied this field for 40 years, and the neuroscience is a little bit behind the behavioral science.
Okay.
So his belief is that the neuroscience shouldn't take precedent over the behavioral science, but it validates, corroborates, confirms everything behavioral scientists, the conclusions that they have reached. And it also provides a source of why adolescents react to negative stimuli.
So then how is it abuse of discretion if there are two strains of science that are not yet in agreement? As you've just said, the expert would have testified that there's a lag in this other area, this other discipline. How is that an abuse of discretion if you've got that kind of proffer?
I don't think they are, and they're actually very consistent. I think for behavioral scientists, they think Yes, we've known this all along,
Yes.
that adolescents have these reactions, and now the actual neuroscience, the brain itself, the anatomy of the brain, and not just the activity of the brain, actually
Yeah, but
confirms this.
unless I'm misunderstanding this
Okay.
argument, which it could be.
Yeah.
As I understood, the point was, that goes to impulse control, not whether or not the impulse control is such that you then would commit a crime.
Again, for this case, I know
Yes.
impulse control is one of the factors that behavioral scientists and neuroscience, they've all studied.
Yes.
But for the purposes of this testimony in this case, it does have to do with that, but it has to do a lot with the fact that as a 14-year-old, where it's more pronounced in him, he's relying on the fear-based part of his brain. And this was a decision he made based on fear, whether he reasonably feared that these rival gang members, and there's a lot of other evidence, and I'm not saying that every time a rival gang member sees other rival gang members, they're going to pull out a gun, but in this particular circumstances that he faced as a single 14-year-old confronted by many rival gang members, commandeering the bus, not listening to the bus driver, blocking off the back exit, having shots fired, and of course that's a little, in the case, it's a little ambiguous, but the police officer did testify that these same young men who were on the bus were in the territory where Kathon Anderson was visiting his grandmother at the time of shots fired. There was a lot of information in the trial that I think does support and lends to the reasonable inference that these gang members were not there to just beat him up. They were there to kill him, and that would have been reasonable for him, particularly based knowing what Dr. Steinberg would have testified to. And I know the record, Justice Fahey, isn't as elaborate as, I mean, even I would like, or that we would like, about, because it wasn't Dr. Steinberg saying all these things, and he's the scientist, so he would have been much more articulate than myself or trial counsel. But there is a lot of scientific evidence that the Supreme Court has basically taken judicial notice of
Thank you, counsel.
in this context.